Good afternoon, Your Honor. Brad Denton on behalf of the plaintiffs.
Good afternoon, Your Honor. Robert Mitchell on behalf of the defendants. I have with us online Marianne Bethay and Emily Wold.
Then you have Courtney Cassiano on behalf of defendants Nathan Skinner, Jennifer Skinner, and Nathan Skinner PLC.
All right, welcome to everyone. We're here for oral argument on defendants' motion to quash or alternatively modify the 6 subpoenas. In the meantime, I got the joint statement of discovery dispute on the request to continue Ms. Bethay's deposition. And so we'll talk about those 2 motions. I will tell you, I know there are several other motions that have just recently been briefed in the last couple of weeks, and I'm not going to hear argument on those motions. I'm just going to go ahead and rule on those motions. So today we'll just focus on the bank subpoenas and the Rule 26D dispute, but you will get my ruling on the other motions shortly after today's hearing. So let's talk first about the motion to quash the bank subpoenas. I will tell you that generally I'm not going to be inclined to allow broad-ranging discovery into a party's personal finances without good cause, and in particular, in this case, my question is particularly in light of the fact that the QuickBooks have now been produced. I'm struggling with why, number one, the request can't be narrowed to specific transactions or specific accounts where there is evidence that money flowed in and out of them, as opposed to broad requests for any and all financial documents, deposits, account statements, everything under the sun for every personal account. And also why those requests can't be directed to the party, as was basically what Judge McCoy ruled back in 2024. So that's where I am headed in with respect to the defendant's motion to quash on the bank subpoenas. As far as the Rule 26D dispute, and we'll talk about that separately, Middlestat is pretty clear on what you can instruct a witness not to, when you can instruct a witness not to answer, and Rule 408 is one of the grounds. Although I recognize that depending on the question posed, there could be grounds to object and instruct her not to answer when there are questions that pertain to or implicate attorney-client privileged communications with respect to the settlement. So my inclination there is going to be to allow a very limited 1-hour continuation of the deposition with respect to to cover the subject of the settlement, to the extent any questions should not be geared toward attorney-client privilege. So I wanted to give you my thoughts on the 2 issues we're going to hear argument on. Of course, I want to hear everybody's position and give you a chance to point to things that may sway me on the issues, but hopefully that'll help you in tailoring your argument today. So we'll start with the motion to quash. Mr. Mitchell, this is your motion, and you can proceed whenever you're ready.
Thank you, Judge Julian, and I appreciate the court's giving us a heads up as to its thinking and concerns. Frankly, Your Honor, you raised all the issues that I wanted to raise. It's the breadth of the subpoenas that we're concerned about, the wholesale, looking into personal finances of the mother who I represent, Ms. Bethay. We had no problem with tailored subpoenas directed to the particular entities at issue, and we've made that clear in our papers. We also have no problem cooperating to the extent appropriate with targeted requests that say, look, we see this transaction coming out of an entity account and going into Ms. Bethay's account. We need further information on that. That, as I think the court's intimating, might be fair game. But this is excessively broad, and that's why we oppose it. We've laid out in our briefs to the court exactly how we think the court might handle this. and which of the requests we think are fair game and which of the ones we think should be limited by the court. And unless the court has questions for me, I have nothing further to offer at this point.
Okay. Thank you, Mr. Mitchell. Mr. Denton?
Thanks, Your Honor. One thing I wanted to clarify, which is that we still don't have the records from the accountant. I thought we would have them by now as well. I've sent counsel for AJW 3 unanswered emails about when we're going to get those, and we still don't have them. I don't think it would be unreasonable to say, hey, once we get to look at those records, let's come back and look at what the issues are. And as Your Honor knows from reading the submissions that we made, at the time we sent them, we didn't have those, or we had just barely received the records and didn't realize at that point that so much was being withheld. Now a lot of what was being held is going to be turned over, or so we're told, but we do not have that yet. And so we're still in a kind of a situation where the context is that Ms. Bethea has this fiduciary duty. One of her duties was to maintain the records of what she did with the plaintiff's money and the huge amounts that she paid to herself. And she either didn't maintain those records or destroyed them or won't turn them over. So we're in a tough situation where, my clients say, well, yeah, I don't know exactly what happened with the records because no information was ever given to us about what happened with our money. And the consistent response from the trustee is, well, you can't tell me exactly which transactions were wrong. And so therefore, you shouldn't be able to find out anything more. We do know that even Ms. Bethea's own expert cannot account for more than $700,000 that's missing. We do know that Mrs. Bethea transferred my client's money to pay off many of her own credit cards. And we do know, of course, that we don't have an accounting from the trustee of what she did with the beneficiary's money. And we know that her longtime accountant, with whom she has a tight relationship over many years, has for some reason resisted turning over accounting records that are obviously standard QuickBooks records to explain what's going on. So our expert, based on the fact that there was a July 15th deadline with respect to expert disclosures, the two experts we have did the best that they could. They have noted major concerns to the extent the court wants to see the concerns that my experts have and the suspicious things that they've pointed out. They're pretty extensive, and I can submit those to the court if Your Honor thinks it would be helpful. But because so much is being withheld, we absolutely need access to the records that were subpoenaed. And I think that it speaks volumes that in the face of all this, that Ms. Bethea's consistent argument is that, hey, you can't point to specific transactional information. This must all be a just fishing expedition. And it's a really bold position to take for a trustee who can't produce records of what she did with the beneficiary's money, and whose own fragmentary records do show that she transferred the beneficiary money to at least 4 of her own accounts. Now, contrary to what you just heard from her attorney, the subpoenas are targeted to the trustee's accounts that relate to the case. There's only 2 types of accounts that we subpoenaed. Those are accounts that Ms. Bethea moved my client's money to or from, or they're accounts that she already produced some of the records of those accounts because they're relevant in the lawsuit. And all we're saying is we want to be able to get the full universe so that when our experts finally do get accounting information, they can look at what on earth happened with the money. Of course, we're fine with those accounts being marked confidential, not being looked at by anybody outside the lawsuit. All that stuff is fine, but we're just in a situation where we're really kneecapped by the behavior of the trustee and her accountant so far in this case, and we're still struggling to get those records.
May I respond or reply?
You can, but I have a question. So just to clarify, you don't have the QuickBooks records yet, and you don't know when you're going to be getting them?
That's right. I've asked Mr. Brower 3 times in probably the last week, and I haven't gotten a response to any of those requests. I'm hopeful it'll be soon. I guess it was my mistake for not giving him a deadline, but I don't know why. I don't know what the delay is about.
Okay. All right, Mr. Mitchell?
Thank you, Judge Julian. My clients take great umbrage and exception to these kind of statements made by Mr. Denton, which are patently untrue. In this case, we've produced over 9,000 pages of documents to them over multiple productions and more than a dozen disclosure supplements and discovery responses. The accountants have produced substantial amounts of documents too, including the QuickBooks records. What this latest argument apparently between between Mr. Denton and the accountants, which we have no role in and are in no way playing a role with. Is there some issue with respect to electronic work papers of the accountant, which the accountant had some issue with, and is trying to resolve those issues with Mr. Denton. But for Mr. Denton to suggest to the court that he doesn't have documents from which he can understand what's going on is completely disingenuous. When I deposed his clients in their depositions, neither one could identify a single transaction which they contend was inappropriate or why. If you read their expert reports, their experts are at a similar loss. They all just simply hope that somehow, some way, this next additional round of documents is somehow going to show some misconduct. And, that's fine for them to hope for and believe, but to continue to cast aspersions and insult my clients by claiming that they're in any way withholding documents, it's just couldn't be further from the truth, Your Honor. And we just take great exception to this. And the day will come where they'll have to put up or shut up. And I'm looking forward to that.
Okay, let me back up and I'll just qualify this by saying I know that the parties are at odds and have very different views of what occurred here. And my role is not to take that side right now. I really am just trying to make sure that the parties have a fair opportunity to get evidence that's relevant to the claims and defenses so that the case is ready for trial or resolution if that's an option. So as far as the production from the accountants, Mr. Denton, can you explain to me exactly what you have and have not received? Because there's a disconnect between what you're saying and what Mr. Mitchell is saying.
Sure. What we received was, Your Honor might remember, I hope it's not inappropriate. Did Your Honor get a chance to review our motion for order to show cause? I think you looked at that a couple weeks ago and granted us a hearing.
Right.
And what happened was the accountant gave us, Your Honor, we go back several months. There was a fight over whether they could withhold the electronic information. Your Honor ruled that they needed to turn over the QuickBooks and that they needed to not redact the fields that said what each transaction was for. Notwithstanding that order, the accountant then turned over the QuickBooks records with several thousand, like every single memo line and every single field or class line was redacted. So we can't tell what the rationale is for every single transaction. That's when we went to the court and said, Your Honor, they're in contempt of your ruling that specifically said not to redact. Your Honor set a hearing for that. I then had conversations with counsel for the accountant. The accountant, after a lot of back and forth, we agreed that the information would be turned over and it would be turned over attorneys and experts' eyes only. And so they said they would do that. And that was a couple weeks ago, at which time we submitted a stipulated motion saying that's what they were going to do and asking the court to vacate the hearing for the motion for the OSC. Your Honor then vacated the hearing. Since then, nothing has been produced by the accountant. So we're still in the position where we have the redacted, unuseful records.
Okay,
So
and I appreciate that there may be more information coming. But my question is more for purposes of the motion to quash. Do the records you have tell you where the money went out? In other words, even if how things are classified and why is something that you're still waiting on from the accountant, if what you have tells you here is where money was transferred out to pay this credit card or for this expense, even if you're missing some other information about that, you can at least say then we want this account statement for this time period because that's where the money went and we want to know how it was used. So you have, my question is really, even though you might be entitled to more information based on your stipulation, do you have enough information to narrow down the scope of your subpoenas for these bank records to particular time periods and transactions so that you're not issuing a broad any and all financial records for these personal accounts for the past 6 years?
I don't think I can intelligently answer that question yet. I apologize. I wish I could.
That's
But
okay.
I do know that when I spoke with our expert, the concern is, well, wait a minute, we know that a whole ton of transactions occurred, but we don't know what they were for. And we don't want to spend an enormous amount of time going through transactions that we don't have the information to know whether they're relevant or not. For example, once we get the memo in the class fields, we might go, oh, well, this is just paying property tax for whatever property. That's no big deal. Fine, we don't need to worry about that. Whereas, there might be other things that we look at that are something that needs to be looked into more. Part of the reason I'm unable to answer the court's question is because I'm not the guy who makes the initial review of those accounting records. I'm not competent to do that. And so I apologize for that.
Well, that's okay. But here's what I'm going to tell you. So I am going to grant the motion in part because the motion does not seek to quash the Bank of America and National Bank subpoenas for the accounts requested, which were numbered 1, 2, 5, 6, 7, 8, and 10, and then for the National Bank subpoena 1, 3, and 4. So you can issue those subpoenas. I'm not going to quash them because there's no objection to them, but I am going to quash the remainder of the subpoenas without prejudice to, I'm not going to go through and narrow these things for you because I can't. I don't have enough information to be able to modify the subpoenas, because what I'm going to ask you to do is I will grant you leave to issue subpoenas, but they need to be limited in their time frame and limited to transactions that you've identified from the financial records as being relevant to the claims. What I'm not going to do is allow a broad subpoena that says we want access to all of her personal financial data. I don't think that's proportionate or appropriate in a case like this, but I do think that you can justifiably request specific time periods for specific transactions that are reflected in the financial records that you have. And I recognize that you may need some time to go through those because the production has been fairly recent of the QuickBooks, but that is what I would expect to happen for any subpoenas that are issued. Obviously, if you can now, because of the back and forth between these parties, the request and the resistance to production, normally I would say get them directly from the party, which is what happened back in 2024. But at this point, if you can narrow down the subpoenas to what I'm telling you to narrow them down, identify the specific transactions and time periods where money is going out that you need verification or tracing for, you can subpoena for those records in those accounts only. But for now, because all I have are these broad subpoenas and I don't have a way myself on the current record to narrow them for you, I'm simply going to grant the motion to quash without prejudice to the reissuance on the narrowed parameters that I'm giving you. And if you find that you are going through and you can't narrow them in the way that I'm asking you to, then you can come back to me and file a motion. But I will need specific information about why your subpoenas have to be as broad as you're asking for them to be. But otherwise, my position is going to be they really need to be narrowed down to the transactions. So that's my ruling on the motion to quash. Let's talk about the Rule 26D statement. As I said, I'm very familiar with the Middlestat case. It's something that comes up fairly frequently in that. I think before that case, attorneys more frequently told that their clients not to respond to questions. And after that case, you really can't. The Court of Appeals made it very clear that if you're not instructing your client not to answer on a privilege, then your objection is to the form of the question and the answer happens. I should qualify that by saying, unless the deposition becomes abusive or harassing, which I didn't see an argument that occurred in this case. Obviously, I have limited information because I wasn't there at the deposition. I don't have the transcript. But my view is that, as I said, I'll allow a short 1 hour continuation of the deposition to discuss the topics related to the negotiation of the settlement without allowing any inquiry into attorney-client communications about the settlement. But I'll hear you all out on why my proposal for resolving the Rule 26D is not appropriate. So I'll start with you, Mr. Denton. You are asking to redepose or to continue the deposition on that topic, correct?
Yes, I don't have anything to add beyond what I think the court has correctly pointed out about the case.
Okay. And Mr. Mitchell?
Your Honor, I understand what your expressed desire is with respect to this. My only concern is, first of all, an hour seems like a lot for this topic of a settlement offer that took place over 5 years ago between different lawyers and the respective clients. But be that as it may, I mean, I assume your order is limited to the scope of this document, this settlement offer, and we can still object to any questioning that would reveal attorney-client privilege. If that's the case, then I understand your directive, and we will, of course, comply.
Yes, and I don't know how long the deposition lasted to begin with. I said an hour because I really just don't know. That doesn't mean it needs to take a full hour, but the topic will be limited to the settlement. And of course, you may instruct Ms. Bethea not to answer if a question is posed that would require her to divulge attorney-client privilege communications. Now, I'll qualify my ruling by saying the fact that I'm allowing the continuation of the deposition doesn't mean any of this testimony is going to be admissible. But again, admissibility isn't the standard for examination under the Middlestat case. And so that's why I am going to allow it to proceed. As far as the request for sanctions, I'm going to deny that request. Obviously, that'll be without prejudice to you coming back to me if things don't go well at the continued deposition. Hopefully they will in light of my ruling today. So I am going to order that the parties cooperate following today's hearing to get the continued deposition set on that topic only. So it's not a free-for-all to expand into other issues. It's going to be limited to the subject of the settlement agreement. And Mr. Denton, you shouldn't be asking any questions that invade the attorney-client privilege. And of course, Mr. Mitchell, you'll be free to object and instruct your client not to answer to the extent any such questions are posed. Okay?
Your Honor, one last question of clarification.
Sure.
Because counsel's office is in far southeast Mesa, is it possible for the purposes of this limited follow-up, we could just do it by video conference?
Your Honor, I'd very much prefer to have it in person. We're not in far southeast Mesa. We're about as far east as the Southeast Judicial Court, and it's not our conduct that have led to this needing to happen.
Well, here's what I will tell you is I generally don't force people to take depositions remotely because it's testimony, even though it's testimony outside of the courtroom. And in my experience, testimony is different when it's being taken in person. Is there a reason that I'm not really hearing a reason that why you can't go take it in person? Other than it's a far drive. Is that right, Mr. Mitchell?
Yes, Your Honor. I mean, it's over 30 minutes to and from my office. I'm envisioning the questions really shouldn't last more than 30 minutes, even though you've allotted up to an hour. That just seems like a waste of resources. But if counsel's intransigent about the issue, I understand if you don't want to order that.
Here's what I will tell you is I'm not going to require Mr. Denton to notice the continued deposition remotely, but in the event, Mr. Mitchell, your client doesn't want to incur the expense of you driving down to the deposition, I will ask Mr. Denton to make the option of you appearing remotely at the deposition possible to save that expense. But otherwise, if he notices that it as an in-person deposition, then the witness will need to appear in person. Okay?
Understood.
Your Honor, could I ask for one quick clarification as well? I know that Mr. Mitchell pointed out the fact that the questions at issue were around a particular settlement agreement, but there are a lot of circumstances around that and how it happened. And obviously, we don't want to have another fight at the deposition. You know, that it's no mystery that this was an issue. It's specifically referenced in our complaint. And I don't want to have any misperception that what Your Honor is saying is that the only thing we can ask is about the specific document as opposed to the circumstances related to that settlement offer and how it was handled and what was done.
Well, why don't you elaborate on what you mean? Because this sounds to me like something that is going to be a problem if we don't iron it out now.
Well, I guess the only reason I thought it was an issue was because of what Mr. Mitchell said, and it sounded like he was laying the groundwork for if I asked about the circumstances that led to the settlement agreement being offered, or the intentions of it, or things like that, that he was going to object to that. I just wanted to clarify that as long as we're talking about the universe of things that are related to the settlement agreement and how it was put forward as referenced in the amended complaint, that's what Your Honor is contemplating.
Well, and yes, I'm not saying you can only ask about the draft document. The circumstances surrounding it are fair game, and any questions that you didn't get answers to at the original deposition because of the objection and the instruction not to answer, you can ask, provided that they don't invade the attorney-client privilege.
Sure. Thank you.
All right. Do we need any further clarification on that?
No, Your Honor. Thank you, Judge Julian. And did I understand with respect to the other open motions, you'll rule on those on the basis of the papers, which I think is great because that way we can resolve them quicker.
Yes, you are going to get like I said, I've been going through them all so that I can get a ruling out to you shortly after today's hearing.
Thank you.
All right.
Thank you, Your Honor.
All right. Thank you, everyone. We are off the record.